tomorrow, Lordship. Obliged, Lordship. May I please, Your Lordship. I crave your Lordship's indulgence to move on. Even if it is a criminal, where FIR has been lost, but it has not been registered.
Criminal petition, you have to mention code to code, PGC case code.
WPC criminal.
Oh.
WPC criminal. Tomorrow, man. But because the urgency is because FIR has not been registered as on today. Third person is still there.
Maybe. My lord, I beg to mention item number 11, my lord. This matter may can be for the time being, my lord.
For the time.
I don't know for the time being, my lord. Obliged.
Case diary is not received? Just a moment. Case diary is not received. What will you do for the time being?
My lord, case diary may not be available, but it is a regular bail application. He is in custody. My lord. I will make arguments, my lord.
Let one motion matter, Lordship, regular bail
Hmm.
application. Lordship. May I pray, Lordship?
Under which sections?
Full, Lordship.
Under which sections?
My lord,
Which sections?
my lord, this is earlier one who it was bail application, your Lordship has already been rejected. Allowed, Lordship.
Under which section? That will be under which section? Have you applied for bail in the lower court? No.
Lordship, this is 380, Lordship.
380, you apply for bail in the lower court.
No, Lordship,
Have you applied
other
for bail in the lower
co-equals bail application has already been granted.
No.
Tomorrow, Lordship.
Apply in the lower court.
Already-
Try your luck in the lower court.
Tomorrow, Lordship.
No,
The day after tomorrow, Lordship.
no. You first apply in the lower court. First,
That is there, Lordship.
you have been rejected?
Yes.
Your bail has been
Yes.
rejected. Sure.
Yes. Tomorrow.
May it please, Your Lordship, I beg to mention item number 8, my lord. This may be listed before appropriate bench on 10, my lord.
Restitute to leave this matter before the appropriate.
And item 7 may be adjourned, my lord.
Learned counsel for the petitioner, Mr. A. Ahmed, has prayed for adjournment. Please the matter on. You have the CD?
Case record, my lord. My lord, another prayer, my lord, in respect of item number 44, my lord. I will list it after vacation, my lord.
Learned
44.
counsel, Mr. A. Ahmed has prayed for adjournment. Please the matter.
My lord, in this case, case record is not received, my lord. That may be called for.
Meanwhile, for the scan copies of the trial court record,
Yes.
along with the scan copies of the CD,
Scan copy of the case record,
NDPS case.
NDPS.
May I please, Your Lordship? Lordship, I beg to mention item number 25. And the matter be taken up after the BU vacation, Lordship.
Learned counsel, Mr. B. A. Chaudhary has prayed for adjournment. List the matter. You have the CD? Item number 25. You have the CD?
25, my lord. We have put the case diary.
Uh,
Remove item number 25, my lord. Other 3 items are taken. Out of the same police station. 16, 17, 22, and 36.
We'll send it back. He's praying for adjournment. In this case, at least we'll send it back. The other cases will take up later. Send back the case diary, call for the up-to-date case diary, list the matter, and we will. 28.
Lordship, there is an interim order that may kindly be continued.
What? Shall I do it? 16 May.
16 May.
Interim order shall remain in force till then.
Lordship, another prayer in respect of item number 26, Lordship. Similar prayer, can it be taken on after vacation, 26?
Sure.
Interim.
Same order.
Both 16 May, Lordship. The interim may kindly be continued, Lordship. Deeply obliged.
May I please, Your Lordship? Lordship, I beg to mention for listing of an appeal, Lordship. In this case, Lordship, the
Listing
appeal,
of
appeal, Lordship, in
appeal you have to mention before PGS kya?
Lordship.
May I please, Your Lordship? I beg to mention item number 20, my lord. Can this matter be taken after BU vacation, my lord?
Sure. Learned counsel,
Yes.
Mr.
May I, my lord, do
B.
that?
Bora has paid for adjournment. Do you have the CD? Send back the CD, call for the up-to-date CD, list the matter on. Interim order shall remain in force till then.
Deeply obliged, my lord. There is an interim order.
20, no?
20, my lord.
May I please, Your Lordship? I beg to mention for listing on AB, my lord, day after tomorrow, my lord. Not so much.
No. Just a moment, not day after tomorrow.
Tomorrow, day after.
You take up before the registry. AB you take up before the registry. Kindly.
Tomorrow, day after.
I have only 3 days left and then I won't be able to complete I will leave it.
On last day 11.
I'll have to leave it because see, Friday, I'll have to complete all my orders. I have to give all the signature. It has to be uploaded, and Saturday morning I'm leaving. Early in the morning I'm leaving for Dibrugarh. I'll just have to leave and go after BU. You give it to Restri, Restri will distribute accordingly because there are 3 benches taking up bail petitions. If I fix the date, then the matter will come before me and it will be cumbersome for me.
New matter for listing matter, not a old matter. So if this honorable court allow, then registry can distribute it, other things.
No, this is not done. This is not done by the registry. If I
Otherwise-
fix a date, then it will come before me. So
Otherwise-
you take, approach the registry kindly.
Oh, my lord, I have no objection to this. Most obliged.
May please lordship, I beg to mention matter BA for listing.
Hmm.
My lordship, I'm behind the bar of 65 days. And the DNA report is rich, my lordship. Kindly matter may be fixed for day after tomorrow. 64, section 64.
BA হয় না?
BA.
দিব লাগিব। On 11.
Okay, my lordship. Obliged.
May I please, Lordship? Because I beg to mention item number 3 may can be fixed after Bihu.
3.
3, Lordship.
Learned counsel for the petitioner, Mr. M. Ahmed has prayed for adjournment, list the matter on.
May I please, your lordship, I beg to mention listing of a bail application. Finally, matter will be listed on day after tomorrow.
Not on day after tomorrow.
Yes. NDPS Act.
You'll have to mention before, কোনখন court আসলে? Before Justice Mitali Thakuria.
Obliged, obliged.
May I please, Lordship? Lordship, I beg to mention item number 22 of the daily list, my lord.
Ah.
60, item number 16 and 17 also similar matter, my lord, of the same FIR. I am bringing item number 22. Lordship may not like to take up the matter, my lord. Senior advocate PJ Sagia sir will appear in this matter, my lord.
Okay.
My lord, I would like
Item number, which item?
item 22, my lord. My lord,
SC to list this matter before any other bench without me.
Lord, may I pray for item
22.
22. 16, 17 similar matter, my lord. My friend appears.
My lord, item 17 also similar, my lord. It was earlier tagged with this.
Item number 22 is tagged, my lord, but this time it has came separately.
No, I cannot send his matter.
Oh,
I'll
my-
send only PJ Sukia's.
My lord, my lord.
My lord, otherwise also, my lord, on the last occasion, your lordship has stated that list for another bench, but it has not been reflected in the order. Maybe because of that listed before your lordship, my lord.
You approach the registry.
My lord.
You approach the
Okay,
registry.
may I pray for a date, my lord? I am not on interim.
No, you approach the registry. If you, I can give an adjournment, but you approach the registry.
Yes.
Here I can send it because PJ Sukia is related
Your
to
Lord.
me. So I'm sending it, but
My
your matter, what should I send?
No, my lord, actually
There
it
has to be
was,
some
it
ground.
was at the stage of hearing, my lord, but now it's listed for motion. Why, I don't know. And earlier, the item 17 was tagged with today's item number 22.
There was an
But
error.
now,
in,
now it has been
typographical error.
tagged with some other matter. My lord, why, how, I don't know, my lord.
No, maybe I think typographical error. I think. Because I'm having many new private secretaries here.
My lord.
And he is a little bit of experience, but other two who comes, though they are very new. So there must have been some typographical error. Maybe I have dictated, maybe they couldn't understand me, maybe there was a wrong
Maybe,
time.
my lord.
May I pray for a date, my lord? My lord, I am not on interim, my lord.
No, I cannot give a date. You approach the registry for the date.
Obliged, my lord. My lord, my item may be adjourned, my lord.
Ah, no, before appropriate bench, no, without me. Without me. Before appropriate bench, no, without me. Any other bench without me.
70. Yes, sir.
It'll be,
May I pray for adjournment?
adjournment, that will be better, no? 16 and 17. Learned counsel, Mr.
I'm sorry, my lord.
M. Suke has prayed for adjournment. List the matter on when do you want?
My lord, Friday.
Then it will come before me if I fix a date.
That's correct. My lord. Simply adjourn, my lord, without
Yeah.
fixing that, my lord.
See, there's a Supreme Court order, it must bail, you have to fix a date. Supreme Court guidelines.
Yes, my lord.
Okay, I'll leave it open then.
Oblige.
Get near na lage, bail positive na lage.
May it please, ladyship. Ladyship, on instruction from the applicant, I beg to mention to adjourn the matter for the day. And item number 13.
Learned Counsel Miss, what is your name?
A. Jubaria. Lordship, kindly be fixed.
On behalf of
after,
who?
RC Das.
Learned Counsel? Naidu? Oh, acha. Learned Counsel Miss A. Jubaria has prayed for adjournment. Is the matter on? CD has called for his receipt.
Yes.
Send back the CD, call for the up-to-date CD. You'll have to send it back. Are you on interim bail?
No, Lordship.
Call for the up-to-date CD. We'll have to send it back. We cannot keep the CD.
May I please, your lordship? Your lordship, I beg to withdraw item number 40 and 41, your lordship. That matter, your lordship, where report was called for whether any FIR has been registered or not from Golaghat PS. Fight the GD
That
number.
report not received, my lord.
That matter, your lordship.
Why do you want to withdraw?
Actually, your lordship, what has happened in this matter, your lordship, we have come to know that another FIR has been lodged, your lordship. Not by that GD number, but another FIR that was directly given to the police station, which has been registered as, your lordship, Golaghat PS 57 of 25, your lordship. But that has been under section 1061, your lordship. And the same FIR, same page, your lordship, which we have annexed in that bail petition, your lordship. So this is bailable offense, your lordship.
Yeah,
So
point,
he can approach before the
Yes.
and
Learned Counsel, Mr.
S. Paul, your lordship.
40 and 41.
40 and 41.
Mr. S. Paul has prayed for withdrawal of the application. Heard Mr. R.J. Borua, Learned Additional PP Assam. Petition is dismissed on withdrawal.
And influx has become influx first. At least.
Okay.
that we can-
Petition is matter stands closed as petition is dismissed on withdrawal to say to kati diba. Matter stands closed as petition has become infructuous.
Deeply obliged.
Lordship, one regular bail application for listing, Lordship. Can do before vacation anyway. Special act is there,
You'll have to mention before Justice Mitali Thakuria.
special act.
May I please, Lordship, I beg to mention item number 27, Lordship. Injury was called for, Lordship. It may be not received.
Item number
27.
at 27 case diary not received.
CD has called for is not received. We should
Interim was
mention
there,
this the matter on. Interim order shall remain in force till then.
Lordship, oblige, Lordship.
I said.
May it please, your lordship. Regular bail application, lordship, FIR at page number 15, lordship.
Page 15, yes.
Page 15, 15, lordship. May I read, lordship?
Yes.
Relevant portion, with due respect, I
My
also.
lord, in this case, my lord, they connected to my lord, one track was stolen, my lord. And it is not recovered probably, my lord. And lordship is, other matter, lordship is already fixed on my lord 10/4/2025, my lord.
Tomorrow then?
Lordship, wait,
10/4, my lord.
lordship, kindly peruse page number 34, lordship.
10/4 is tomorrow, I think. Day after tomorrow. Okay.
One agrees already.
Call
been
for the
received.
CD list the matter on 10/4.
Lordship, may I submit something, lordship?
10/4, day after tomorrow. Item 2. That was stolen.
10. 10.
10/4.
10. Similar matter is fixed on 10, lordship.
Yes. 3-4 matters.
DA number 1063.
PA number one.
1063.
List the
number.
matter on 10/4 along with.
DA number
number?
1063. 25.
Item 2.
Bless.
In this case, report was called for, my lord. In this case, report was
Okay.
called.
Do you have the report?
My lord, report received, my lord.
Any case has been registered?
No case, my lord. No case has been registered.
Learned Counsel Mr. I. Chaudhary is present for the petitioner. Learned Additional PP Mr. R.J. Borua has submitted that no case has been registered against the petitioner. So I'll dismiss it. Petition is hereby dismissed.
Blood.
Item 4.
May I be lordship?
Yes,
Lordship
sir.
petition before lordship is petition 482 lordship. FIR is lordship page 8 translated copy lordship. And it is registered under 1 on 7 and especially 76 and 75 section is there. After the restart of the notice, I have served me a
No,
notice,
but you got
lordship. Page 12 is the
What do you have in the FIR?
My lord.
What do you have? Oh, sorry, in the CD?
my lord, then my lord,
Case diary, my lord, the article, my stolen article not recovered as in.
Abdul Mia.
um, I have been arrested, my lord.
Yes,
Lordship.
Abdul Mia, my lord, allegation is that, my lord, he was the driving the vehicle, my lord. That is the allegation against him, my lord. And my lord, he was arrested, my lord, and as on that, my lord, 19 days, he's in custody, my lord. The stolen articles has not been recovered, my lord.
Okay, then we'll grant him bail.
My-
19 days cannot recover stolen articles.
my objection will be recorded, my lord.
Have you applied for bail before the trial court?
No, my lord.
Why not? You apply for bail before the trial court.
For our,
This is a theft case.
Lord.
You have to apply for bail before the trial court.
next time, my lord, we'll take care of
See, 3
Lord.
years I have completed in this court.
it. Lord.
And
Because,
the
my lord, there
same
is no-
advice
there is-
I am
Well, because, my lord, there is no bar in this, on our Supreme Court also, my lord. Lord.
same advice
Lord.
I'm giving every time.
Lord.
And the same answer is coming
In
from the bar.
Kejiwal's case, my lord, the Honorable Supreme Court clarified that position also.
Third learned counsel, Mr. R. Ali for the petitioner. But you see, this has not been done away with.
Okay.
You'll have to exhaust everything. And then you, preferably, you have to exhaust every possible means in the lower court and then approach the higher court. And this has not been done away with. It's still there, still existing. For the petitioner Abdul Mia, who has filed his application under section 482 of the BNWS 2023 with prayer for bail, as is behind bars since
23, 22, 3, my lord.
in connection with so-and-so PS case under so-and-so sections, third Mr. R.J. Borwal, learned additional PP Assam. The allegation against the petitioner is that he is involved in committing theft of IMFL, no?
Lord.
IMFL, full stop. The
600 cartoons of IMF, my lord.
600 cartoons of IMFL, full stop. The learned additional PP has raised objections stating that they are incriminating materials in the case diary, as the petitioner was the driver of the vehicle carrying 600 cartoons of IMFL. It is further submitted that the stolen articles are yet to be recovered, and if the petitioner is enlarged on bail, investigation may be adversely affected. I have considered the submissions at the bar with circumspection. The petitioner is willing to cooperate with the remaining part of the investigation. Considering all aspects, I have also scrutinized the case diary. It appears that custodial detention may not be required to further the investigation. Considering all aspects, petition is allowed. The petition is allowed on bail of rupees 30,000 with a suitable surety of like amount to the satisfaction of the Amin.
Amin Governor, Chief Judicial Magistrate,
CM
Kamrup Amin.
Amin Ka under the condition that the petitioner shall appear before the IO on every fortnightly completion of investigation. The petitioner shall refrain from such activities with which is alleged. The petitioner shall not leave the jurisdiction of the court without prior permission, and the petitioner shall cooperate with the investigation. On breach of any of the bail conditions, the court is at liberty to cancel the bail granted to the petitioner. Send back the CD.
My lord, he is from Borpeta, my lord, and
Oh, hey, to লিখি দিবা, এটো কাটি দিবা, delete কৰি দিবা. To shall not leave the jurisdiction of the court without prior permission.
right.
Made special lordship. FIR page lordship 10 lordship. Today is 70 days lordship.
70 days.
Maximum punishment is 10 years lordship.
You have the CD?
CD is there.
What do you have in the CD?
CD we have lordship. The
Person is Joel Khan.
Royal Khan lordship, the recovery has been made. One SBI Global debit card belongs to Biju Sharma, bearing so and so in his house lordship. Again, lordship, one SBI Global debit card of Nripendra M. Sharma bearing so and so. So the recovery is made in his house during search. Moreover, he is a habitual offender. And case number is also there.
Mm.
He was earlier arrested in connection with Dispur PS case number,
And the murder also.
Lordship.
So you see, now that Bhyan Kumar judgment, you are very ready with Bhyan Kumar judgment. There's another judgment come up recently that you have to give all the antecedents while applying for the bail. But you all are not giving the antecedents. That boarding report brings the antecedents. So Bhyan Kumar, after Bhyan Kumar judgment, we have another judgment of the Honorable Supreme Court that you have to place the antecedents, but it is not coming up. I've not noticed any antecedent. Whatever antecedent is coming up from the boarding reports. I'll grant bill. 70 days.
But materials are there, Lord.
I know.
Okay.
You see, this is dowry debt, not murder, dowry debt, worse than murder.
Okay.
And the investigation may be adversely affected. It is further submitted that the CD also reveals that there are incriminating materials in the case diary against the petitioner. So on what conditions should I release him on bail?
For length of the detention.
No. Length of detention not for a history sheeter with 4 cases of robbery and 1 case of dowry debt. You give me a condition. On what condition?
So now he is Lordship under treatment, Lordship.
Under what treatment?
Lordship, he was fired by the police, Lordship, in the leg, Lordship.
Oh my God.
He was initially
Tried to
admitted,
escape.
Lordship. He was initially admitted to the DMC, Lordship. Later on released. Now he is in Malapur jail on medical treatment. Like that. In forwarding report, it is mentioned, Lordship. Page 12, Lordship. Second para, Lordship.
It is submitted on behalf of the petitioner that the petitioner is undergoing treatment at GMCH as he tried to escape while in police custody. Escape from police custody, likh diya. It's a very aggressive. I don't know. I don't think so. He deserves bail. Very aggressive.
Now, Lordship, he is not moved here and there, Lordship, only bed.
So that this is the last case, or does he have any other case pending against him?
No, this is last case, Lordship.
Other cases he has been granted bail.
Lordship.
That dowry debt case.
Already granted bail, Lordship.
Trial court.
Hmm.
At least I may be allowed to contest the case, madam, at any condition. Already allegation level against me is 436.
Hmm.
Despite the fact that prima facie does not appear that any case is made out, but I'm not going on that, my lord.
Yes. Charge sheet has been submitted against you showing you as absconder.
No, no, yes, no, no, absconder actually, I have duly
Ah.
cooperated with the investigating officer.
Ah,
After having charge sheet filed,
ah.
I became absconder.
Okay, okay. You are not, charge sheet is not, you are not shown as absconder in the charge sheet.
No, definitely not.
So
I was on
during trial, you disappeared.
Yeah, during trial, during inquiry, in fact.
Mhm. Okay. For how many days?
Around
1 year, 2 year,
4 years
4 years,
during COVID period, my lord.
during COVID period.
So whether SARS frame or not, my lord, that is it.
So it was not fair because it's a committal proceeding.
Has not frame.
Case has been committed. Case is required to be committed from the judicial magistrate onward after the session court. At that time, CGM is asking for me to appear by issuing a warrant of arrest. That is why I apprehended.
Where is
arrest.
your ground in the petition?
I do not have get any knowledge, and I was under the impression that no case is made out against me.
Which paragraph? Okay, I got it. Paragraph 6, no?
Yeah, my
436. Yes, can appear. Okay. He'll appear, face the trial, charge will be framed.
My lord, I leave it to your lordship.
Give it a record,
Yes.
trial court record. Art, learned counsel, Dr. T. Kolita Porter, and Vinod Chandak also.
Yes.
And learned counsel, Mr. V.K. Chandak for the petitioner. C. Bolen Kus, who has filed his application under section 482 of the BNSS 2023 with prayer for pre-arrest bail, as he is apprehending arrest in connection with this case. It is submitted on behalf of the petitioner that he had cooperated with the investigation, but he had to leave for Kerala, no?
Yes.
South India. Okay, he had to
South
leave
India.
for South India to earn his livelihood. The petitioner was not aware that the police was searching for him. When he returned in the month of December 2023, he learned from his native villagers that the police was searching for him. So post of apprehending arrest the petitioners before this court.
Look, only one question, my lord. My lord, what I have seen, my lord, the PNA has been issued, my lord. Whether after issuing of
Give
the,
in abeyance.
whether after issuing PNA, my lord, can this honorable court, can my lord grant the privilege of pre-arrest bail, my lord?
He'll appear and
Of course, my lord. In the case of Lovesh Kumar, Hasab NCT Delhi, it was very clearly stated by the Honorable Apex Court that in a normal case, it cannot. But in an exceptional cases, where the accused has cooperated with the IU, subsequent for which, consequent of which, charge sheet has been filed.
But in this case, he is not cooperating
So
with the
that was
trial,
a-
my lord. Because he was declared absconder, my lord. He was on absconder in the search sheet, my lord. Then he was
No, no, no.
arrested, my lord. He appeared
he
in
was
the
not
trial.
for
No,
absconded in charge sheet,
not
no?
as absconded charge sheet. He was initially in jail hazard, subsequently released on bail. Subsequently, charge sheet has been filed. During inquiry time, summon has been received by my mother, but there is nothing on record to show that my mother is living with me. According to 66 of the BNSS, it was clearly stated that a duplicate summon can be left to the adult member, provided the adult member must have to be lived with the person concerned. But there is nothing on record to show that my mother is living with me. The fact that I'm keeping apart from my mother, since my childhood, I'm living with my brother-in-law. So everything available with the record, my lord, with all humility. And I pray before your magnanimity that your good office might be magnanimous to allow me to contest the case.
So this order dated 19/9/2023
My lord,
that PNA issued against the accused has been returned without execution
my lord,
report. NBW was first issued on 6/1/2023. And
My
on
lord,
the basis
moreover,
of non-execution report, PNA was issued. So then again, the CJN, he
actually I have not
he
declared
issued
still
one fresh
absconder.
NBW against him.
Yeah, I'm not still declared absconder. And on the defect of the case is that, my lord, before issuing any proclamation, attachment has been issued by the learned court concerned.
No, then again, then he has given a reasoned order to issue simultaneously PNA and NBWA.
because my lord, this is an anticipatory bail application. It is not a criminal petition, my lord. Wherein my lord, then lordship has got inherent power.
No, I will not.
To my lord, stay or
Yes,
my lord
yes,
to set aside,
stay,
my lord,
PNA and
PNA order.
NBWA, yes. I
My
cannot
only-
pass any order.
my lord.
It
My-
has to be a criminal petition
Yes, my lord,
to
that is
keep
my
the NBW and PNA in
PNA
abeyance.
issue, my lord. In this case, my lord, he has filed a pre-arrest bail application. Question is that, my lord, why he is apprehending us? Because he is not cooperating, my lord. That is why, my lord, non-bailable warrant and my lord, PNA has been issued, my lord.
This case has been filed.
Not case will file.
Based-
Actually,
based-
I am not still yet to be declared
Hence, this case
absconder,
is
my
filed
lord.
at this stage.
Yes, my lord.
I am yet to be declared
I think
absconder.
your proper way will be to file a petition under section 482.
No, whatever. Lovesh Kumar is very clear, my lord. Lovesh Kumar and
You
NCT
give me
Delhi.
the
It is a
judgment.
very clear case
You give me the
where the
judgment.
ratio of law as propounded by
Yes,
the
my lord,
Honorable Apex Court is
let
that
him furnish the, my lord. Let him furnish the, my lord.
in a normal case.
Judgment of the, my lord,
No,
lowest.
I think 482, if you file a petition under
That I
section,
do admit, my lord.
then I will
But so far my
pass an
learned
order for you to appear and I'll.
Yes,
and
yes,
the-
that
State
can
council
be
is
done, my lord.
concerned.
Huh?
That's he, my lord, he be silent.
There's a better relief that way. So I will pass an order to keep the NBW and PNA in abeyance.
Yes, my lord, yes, that can be done.
The
when, my lord,
NBW and PNA will be kept in abeyance. I'll pass an order. It will be better to file an application under along with this application.
my lord,
Both can
this
come up
is-
together.
This application, my lord, I think, my lord, lordship cannot, my lord, my humble service, lordship may not pass any order because, my lord, it's an anticipatory bail application, my lord. If they
No,
file
here
any,
you file. Here
Yes.
I won't pass. I'm just suggesting
yes,
for
my lord, if they
a.
file any application, my lord, for passing of that order, my lord, passing of the order, PNA or non-bailable, my lord, then lordship can, my lord, keep in abeyance but that order, and he, my lord, may be directed to appear before a
We'll
trial
dispose
court.
of the petition and I'll keep the NBW and PNA in abeyance like other cases which can be done.
Yes, man.
We can do that.
Now, what will be the order,
Yeah,
my lord?
because as it is,
Today?
you're willing to appear. I think it will be better. As it is, you're willing to appear. So
Yes,
where is the catch? No harm
It
in.
will for the betterment of the trial only, my lord. If the trial will proceed then.
Yeah, why should we keep the trial pending? So this has been filed. This case has been filed. Last order he has submitted like that.
Case 22.
And he was declared a proclaimed absconder. This is 25/3/2025. I don't think you have this order with you. You don't have this order. Because this petition was filed before that. He has been declared a proclaimed absconder. No, you don't have, because this petition was filed on 18 March and this order was passed on 25/3. So you were not in the knowledge that he was declared a proclaimed absconder. I think you'll have to file a petition for quashing.
No, my
that
lord,
order.
kindly see. Uh,
On the hit to-
Page number
No, 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 you see
Right here.
this order. You have, huh?
This was record to file.
Let me see.
25/3. Before this order, you have filed a petition because you didn't know that he was an absconder. On 25/3, he was declared an absconder. You can see there's a copy of the order. So I didn't know because I was going by your application. He only pointed it out to me. I didn't check the LCR. We'll keep this pending, or you can withdraw it, or I think we'll keep this pending. Meanwhile, you file one petition, criminal petition. After you file the petition.
Still, any order can be passed regarding.
What to do? You want to withdraw this petition, or should I keep it pending? For under date till the time you file the petition, I'll keep it pending.
Let me be pending.
Okay. Release this matter on behavioral detail. 25th April.
May I please, your lordship? Lordship, in this matter, the offences are related to forest lordship. Offences are related to forest lordship.
Forest, so
Their name has not been shown lordship in the first list.
Standing outside forest may be shown. Wildlife may forest.
you have made him a party?
Sorry.
Have you made him a party?
Yes.
Learned counsel, Mr.
D. Chaudhary.
D. Chaudhary is present for the petitioner. Ready to reflect the name of special PP forest in the cause list as respondents.
Yes. May I pay for a date on Friday, lordship?
Sorry?
On Friday.
Friday. I don't know.
So there is some urgency.
This is last
It's
matter.
the second.
That's last matter.
Forty-two application, your lordship.
Hmm?
42 application, your lordship.
Okay.
FIR is page 10, your lordship. The translated copy. Particular person is page number 14, your lordship. May I read, your lordship?
Yes.
সম্মানপূর্বক বিনতি
Your life.
Finding item 6. May I please tell you? And on the last occasion, I had filed an additional affidavit.
Grounds
taking-
of arrest.
Yes, taking the ground of arrest manner. And now I have applied certified copy which I have collected. I would like to place this. That no grounds was not mentioned.
Mentioned. The case number is mentioned. He has given his signature in English.
Case number is mentioned, but grounds, under whose circumstances, and in what offense, and in what positions that I have
It's
been
required
arrested.
to be written down.
Written, my lord, the grounds,
Where-
grounds should be written, my lord. It is taking this plea, my lord, the
Like
coordinate.
para 3, you read para 3. Para 13. You read para 13
Of my affidavit.
from middle part. No, Vyan Kumar judgment.
Yes, ma'am.
Middle part you read para 13 from middle part.
David, this one, I like this.
Para 13 of beyond judgment.
13 man. It is an admitted position that the detainee does not know English. The grounds of detention which are served on the detainee have been drawn up in English. It is the true that Sri Sriyal Anthali Police Inspector who served the grounds of detention on the detainee has filed an affidavit stating that he had fully explained the grounds of detention in Gujarati to the detainee. But that is not a sufficient compliance with the section, the mandate of Article 22(5) of the Constitution, which requires that the grounds of detention must be communicated to the detainee. Communicate is a strong word. It means that a sufficient knowledge of the basic facts constituting the grounds should be imparted effectively and fully to the detainee in writing in a language which he understands. So that paragraph comes in favor of me, man.
Then again you read.
Yes. The whole purpose of communicating the ground to the detainee is to enable him to make a purposeful and effective representation. If the grounds are only verbally explained to the detainee and nothing in writing is left with him in a language which he understands, then that purpose is not served. So, and the constitutional mandate in Article 22(5) is infringed. If any authority is needed on this point, which observes Article 22(5), reference may be made to the decisions of the court in Hare Krishna Swansaswans.
Then again.
Therefore, as per Article 22(1) is concerned, compliance can be made by communicating sufficient knowledge of the basic facts constituting the grounds of arrest to the person arrest. The grounds should be effectively and fully communicated to the arrestee in the manner in which he will fully understand the same. Therefore, it follows that the grounds of arrest must be informed in a language which the arrestee understands. That is how, in the case of Pankaj Bansal, this court held that the mode of conveying the grounds of arrest must necessarily be meaningful so as to serve the intended purpose. However, under Article 22(1), there is no requirement of communicating the grounds of arrest in writing. Article 22(1) incorporates the right of every person arrested to consult an advocate of his choice, and the
Not required to be in writing.
required, my lord. Required, my lord. This
There
if the
are two judgments. One is Hare Krishna and one is Pankaj.
So, my lord, this Bihans Kumar is also affirmed by the recent judgment Ashish Kakkar. It is passed on 25th March, my lord. This is also said, it is also, my lord, it is also said that, my lord, the
The paragraph 21 also nowhere it is written that it must be in writing. Only the grounds of arrest has to be communicated.
here in this case, my lord, specific grounds is not mentioned. This is only saying that you are arrested in such and such cases. This is clear, my lord. Grounds are not taken under which circumstances, in what position, and what the offense I have made for which I have arrested. That is not mentioned, my lord. Where the grounds is mentioned, my lord, I have seen, I have filed the additional affidavit in this regard, my lord.
I have seen it is, I think this is sufficient. Sufficient grounds of arrest has been given. He has taken it down in English. He has given his signature in English. And then
my lord, giving the signature in English and the understanding English language.
Time for the IO to reply that he could not understand this language. Why he has taken it in given his signature in English? The IO has to reply. How will the APP know whether the grounds of arrest was communicated or not?
That, my lord, on the last occasion, the affidavit has served, my lord. On the last occasion, on the 7 to 8 days back. And the last occasion, he said that, yes, they will go through and they fixed it on today, my lord. On the last occasion, it was listed. So my humble submission that apart from the grounds of arrest, other grounds is all.
Vihan Kumar's case is absolutely different. How that a person who was I think his charges were under the PMLA Act.
Yes,
how he was treated, he was chained to the bed. The judgment is absolutely different. If you see murder case, aggressive accused in a murder case, aggressive drug peddler, if you everything, all these people who will come up and say, they will definitely say because they are very aggressive. So they know how to defend themselves. They'll come up and say, no, I didn't understand what he has stated. So everybody, they will be on the loose. And they will be a threat to every normal citizen in this world. If where statutory, what is the meaning of statutory embargo? Statutory embargo means the cases offense is serious, heinous. They must not, there should be some sort of deterrence. If they are on the loose on the grounds of arrest, we also as a people in the society have a duty towards our safeguard our citizens of the society. It's not that we want to reject bail to innocent people. No, never.
This is right, but here in this case, that apart from the grounds of arrest, my another plea is that I have been in custody since 1 year, 10 months, 679 days. Till now,
Okay.
so this is also another grounds is a prolonged incarceration.
Any witness has been examined?
No examined, no witness examined. No witness examined,
Not a single witness has been examined for
not examined, madam.
1 year, 10 months.
Yes, madam.
Then why you are coming up with grounds of arrest?
Grounds of arrest also, my lord, I am taking this because in many other, my lord, learned Supreme, on the basis of the learned Supreme Court judgment, our coordinated benches passes the giving relief in this aspect, my lord. Many other judgment
You
is that
see
I
what
have.
will happen to the society now? If everybody is out on grounds of release 103, 302, 295, 297,
This is another,
121A,
this is
120,
another aspect, but
121A.
but we cannot overlook the constitutional mandate, my lord. Article 22, fundamental rights, my lord.
Grounds of arrest are well explained to them. They know why they are arrested. Everybody knows very well why they are
It
arrested.
is a presumption, my lord. We are not-
This is a very good democratic country. Everybody knows why they are arrested. I believe so. I have faith in this country. Everybody knows why they are arrested. But this case was really bad. Bian Kumar's case. He was chained to the bed. Yes, PP.
Yes, Lordship, the person here is in his conscious position. This commercial quantity of heroin is found, Lord.
Heroin.
Heroin, Lord.
How many kgs?
300 gram, Lord. 250 is recommended.
Less than half kg. Yes.
No, my lord. It's not
And
3.5
moreover, Lordship, in his conscious position, of the four persons are there in the car.
gram only.
Vehicle, Lordship. And these things has been found.
1 year, 10 months, he is not a single witness has been examined.
Actually, Lordship, in what I have seen in the record, Lordship, on 5/6/2024, it is stated that, Lordship, someone returned with report and one as served. And on 31/7/2024, two of the witnesses, they were present but could not examine. But the reason is not there why they have not examined, Lordship.
Which court?